Hello and welcome everyone to our webinar, Introduction to Contracts for Small Business Owners. We are excited that you have joined us tonight. This webinar is brought to you by the BLDC, the Boston Local Development Corporation, and the Transactional Law Clinics of Harvard Law School, TLC. My name is Gisela Soriano, and I'm part of the BLDC, and I'm happy to be here with you tonight. Now I'm going to give the floor to Bill Nickerson, who will introduce himself and speak more about the LDC.
Thank you, Gisela. And I'd also like to welcome everybody. Tonight's our third collaboration with the good people at the Transactional Law Clinic at Harvard Law School. And as people sign in, I hope more are signing in because this was a record for us in registrations. So hoping that the turnout continues to grow. Just a few words about our small business loan fund, the Boston Local Development Corporation. First of all, we had a lot of initials floating around. Gisela and I work for the BPDA, which is the Boston Planning and Development Agency. We administer this program, the Boston Local Development Corporation. The BLDC is actually a 501c3 nonprofit corporation, and it's governed by an independent board of trustees. There's their smiling faces. The day-to-day operations is provided by us at BPDA, our accounting support staff, etc. And we make small business loans. Simple terms, we make small business loans up to $250,000 for commercial, industrial, and service companies that are located in the city of Boston. I will just note, if anybody out there is on this call, if you're interested in small business assistance like ours, but you're not in the city of Boston, first of all, I'd suggest you move to Boston. But if you're not going to do that, if you get in touch with us after the fact, we have a lot of partners that don't have our demographic limitation that we could, geographic limitation that we could refer you to. Over the years, we have made in last 20 years, about $20 million in small business loans, leveraged over $95 million through Boston's banking community relationships. That's very important to us, and it allows the small business owner to develop a long-term relationship with a bank and not just a one-off borrowing relationship with us. Again, this is probably a very low number, but as an estimate we use to date, we've created and retained over 3,500 jobs in the city of Boston. Next slide, please. This is just to give you an idea of our eligibility process. As you can see on this list here, what we ask folks for with an application is exactly what a bank asks folks for. You know, we can lend to pretty much any type of corporate entity in the city of Boston. Our underwriting standards are similar to the banking industry. Then you say, well, then why do you folks exist? If I just go to the bank and if I can't get a bank loan, I can't get a loan for you. That's really not true. Sometimes there's a lot of technical circumstances that don't allow a bank to make a loan that we can work with. We also understand that we have a mission, and the mission that we have is to fill the gaps in the system, hopefully. And the biggest issue that keeps folks, small business owners, away from a bank is equity. It's ironic the term equity has two uses these days. We hear about equity in the case of providing equality for folks and equal access for folks, and that's actually translates into the traditional banking term of equity, which is cash in the business, which is collateral. Those lack of cash and collateral for small inner city businesses starting up is a direct result of the lack of historical equity in our society. So that's really the target difference. Cash flow is cash flow. You can't borrow if you can't show that you can pay it back. But we do we understand that we'll be taking a position on assets of the business that may not be as strong as that a bank will take. Next slide, please. We run into, as I said, we're a City of Boston program. We run into an issue a lot where people say, well, yeah, I'm in Boston and they're in Norwood. Or I've had the reverse. Someone said, gee, I wish East Boston was part of Boston so you could give me a loan. And so, well, you are. So this is a list of the actual neighborhoods that constitute the City of Boston, just as a quick snapshot. And we'll be sharing these slides afterwards. So if you want to check and make sure whether or not you're in Boston, you can check then. Next slide, please. And I would just like to show a few of our borrowers. We have a very diverse group of borrowers. Just recently, we closed a loan to Lazy Bear Creamery, family-run operation, woman-owned business in Dorchester. Highly recommend the place. Ice cream is great, and they make their own waffle cones that my daughter, who lives near there, says they are to die for. Marvelous Cuts. We worked with Lex, a gentleman who owns Marvelous Cuts. He originally had a barbershop in Brockton and wanted to make himself a presence in Boston, in Boston also. We worked together with finance this location, which is a beautiful place in Boston's financial district. He's doing excellent there. And that all happened just coming out of COVID. So we had all those impacts. He's doing very well, very proud of that business also. Next slide, please. And this is a very nice comment from one of our other recent borrowers. Tracy Skelly opened a place called the Little Cocoa Bean. It's a baby spa in Jamaica Plain. It's incredibly cute. It's for very small infants, and she did a whole wraparound system of foods and support products for parents, mixers and other products. The origin of it is she's a Panamanian, her family's Panamanian background. When she first had her baby, she said, gee, I didn't see any of the food that looks like what I ate as a baby. And so she started putting it together for herself and found there was a real interest in not only in, as she said, food that looks like what she grew up on, but also that doesn't have any preservatives or anything. It's all fresh. It's actually freshly ground up and put together. And the place, if you're in Jamaica Plain, go by there. It's an incredibly cute little place, with little tiny chairs for the kids and stuff. And now let me pass it back to Gisela.
Thank you very much, Bill. Now I would like to take a moment to provide a few words in Spanish about our loan program. Buenas noches, mi nombre es Gisela Soriano y trabajo para la organización Boston Local Development Corporation, BLDC, por sus siglas en inglés. El propósito de nuestra organización es ofrecer préstamos a pequeños negocios localizados en la ciudad de Boston. Aquí en este gráfico que pueden ver, tenemos más información sobre nuestros requisitos. Y acá, a la mano derecha, indicamos lo siguiente. Nuestros préstamos pueden llegar hasta la cantidad de $250,000 para aquellos negocios en los sectores industriales y hasta $150,000 para negocios en otros sectores. Así es que si usted es dueño o dueña de su negocio y está buscando capital, será un placer ayudarlo o ayudarla. En el chat voy a escribir la dirección de nuestra página web para que obtengan más información sobre nuestros préstamos e información de cómo aplicar. También si tienen alguna pregunta durante la presentación, por favor escriban en la sección de Q&A, Question and Answer, localizada en la parte de abajo de su pantalla. Muchas gracias por estar con nosotros esta noche. So here we are, the team of the BLDC program. Here's our contact information. If you are a business owner in need of funding or looking to open a new business in Boston, we would welcome the opportunity to help you. In the chat, I will write our website link for more information about our business loans and application eligibility. And if you have any questions during our presentation, please type them at the bottom of your screen using the Q&A feature. Here's what it looks like. At the end of the presentation, I will read out aloud the questions, and after the questions in the Q&A have been answered, we will also open the floor for our guests today, you, to ask questions verbally. And so I'll ask for you to raise your hand, as you can see here in the bottom of your screen, and also here in this slide. And now it is my pleasure, stop sharing, to introduce the team at the Transactional Law Clinics of Harvard Law School, TLC. We have several amazing folks here tonight. I will give the floor first to Dee, student attorney at TLC. Dee?
Thank you so much, Gisela. And I think we're going to start sharing our screen shortly. Okay, there it is. Great. Well, thank you everyone for joining us today. Again, my name is Dee, and I'm a third-year law student at Harvard Law School. I'm a student advocate at the Transactional Law Clinics, where we provide legal assistance to small business owners in many areas, including business formation, commercial leasing, permitting and licensing, and of course, contracts. And tonight I'll be presenting along with another student advocate, Sasha.
Hi, everybody. My name is Sasha. Thanks so much for being here tonight. Really excited to be here with you to talk about contracts. I am a second-year law student at Harvard Law School and also a student advocate at the Transactional Law Clinics with Dee. I will talk to you guys later on in the presentation.
Great. And we're also joined tonight by our clinical supervisor, Patricia Alejandro, who's an experienced transactional attorney and has been supporting us in creating and bringing this presentation to you. So before we jump in, just a quick disclaimer that the information that we're providing today is not intended to be legal advice, and that we encourage you to seek out legal counsel if you are figuring out something about your individual needs. And this presentation will be recorded, as Gisela mentioned at the beginning. Great. So a brief roadmap of what we're going through today. We'll do an introduction to contracts, how contracts are formed, and then I'll turn it over to Sasha for common terms and breach of contract. And then I will close us out with practical tips before we move to the Q&A section. So to start us off, definition of a contract is a legally enforceable agreement between two or more parties where each party will do something in exchange for receiving something else. And contracts are governed generally by state law. And so in this case, Massachusetts law. But there's also a more generally wide set of rules called the Uniform Commercial Code that deals with the sale of goods. And this has been adopted by most states, including Massachusetts. One thing to keep in mind when it comes to contract enforcement is to know that contracts are not automatically enforced under the law. If anything goes wrong, one of the parties must sue the other party to have the contract be enforced by the court. Hopefully with this presentation tonight, it'll help put you on the path to not having to deal with that ever. So contracts are all around us, just as people in everyday life. There's what we think of as the more obvious contracts or explicit contracts. So this is when you're signing up for a new website or you rent a car and you see that big block of text pop up and you have to check that you've read the terms and conditions. But there's also implicit contracts, which we enter into all the time, probably without realizing it. So this can be something like paying someone to cut your grass or even ordering food at a restaurant. Of course, everyone here tonight is a business owner. And so in business, there's a whole, set of contracts that we deal with. That's everything from service agreements, employment contracts, and commercial leases. In terms of the benefits of contracts, the first thing is that it minimizes the room for confusion or misinterpretation, and it clarifies the risks and the duties that each party has. The second benefit is that it minimizes any chance of business disagreements or the loss of business relationships. It reduces the potential for litigation, and it creates a plan in case any disputes arise in the future. Of course, there's still limitations to contracts. Obvious one, it costs time and money to write and enforce contracts. It can also create confusion if a contract is poorly drafted or filled with jargon. And lastly, a contract can only anticipate a limited set of possible scenarios. And so as careful as we can try to be, there are some things that we can't anticipate. Next, we'll move on to contract formation. So you can think of a contract as having 3 different parts. There's the offer, acceptance, and consideration. So offer and acceptance are a little bit easier to understand, but consideration might be a new term to you, and this is the benefit that each party receives in exchange for what it gives up. And a lot of the times, this is the money that you're paying for whatever good or service you're receiving. So to make this a little bit more interesting, we created a case study that will hopefully guide us through the presentation and give you a good real life example. So I'd like to introduce all of you to Doug. Doug is a first-time business owner, and he's opening a coffee shop in Dorchester. He's been in the restaurant industry for years, so he has some familiarity with contracts, but is worried about protecting himself and his business. And one of the first contracts that Doug is dealing with is setting up a service contract with Berkeley Linens, which is the company that will wash his coffee shop's linens and rags every week. So in this scenario, Doug and Berkeley Linens have an initial meeting. And after the meeting, Berkeley Linen sends Doug a contract. And this contract states that they will charge $125 per week. So Doug goes back and consults some of his friends in the coffee and restaurant industry, and they tell him that $125 sounds like a bit of a high price. So Doug's attorney marks up Berkeley's original contract, changes the price to $100 per week, down from $125, and emails it back. So now this is Doug's counteroffer of $100 per week. And so let's see how this example falls into the 3 different contract ingredients that we talked about. So we'll start with the easy one, which is consideration. And in this case, Doug's consideration is the promise to pay $100 for linen washing services. Moving on, the offer or proposal, there was 2. The first one was Berkeley's quote, which listed $125. And then the second offer or the counter offer was Doug's contract, which listed $100 as a weekly price. For acceptance of the proposal, Doug has sent the $100 contract, and Berkeley signs, dates, and returns the contract agreeing to $100. And generally throughout this presentation, we will be assuming that there is a written contract with a written acceptance because that is best practice. That being said, there's also a couple different ways that Berkeley could have accepted the proposal, which we will talk about briefly, just so you're aware. So in this case, this is an oral acceptance. Let's say that Doug runs into his Berkeley representative, and the representative says, "Hey, Doug, I saw your email this morning. $100 sounds like a fair price." And so in this case, Berkeley has made an oral contract by accepting the price in person. And legally, oral contracts are enforceable, but as you can imagine, they present a lot of difficulties when it comes to enforcing them because it's hard to prove. It forces courts to have to look at contextual evidence like conduct before and after the disputed contract, the credibility of the parties, and eyewitness testimony. And generally, it can turn into a he said, she said battle, which is why we recommend having a written contract. Another method of acceptance is acceptance by performance. So in this case, let's say that Doug doesn't receive an email back with the signed contract from Berkeley, but the first time his linens are taken and washed and returned, the invoice states that he's being charged $100 for the weekly service. So why should contracts be in writing? Number one, it prevents conflicts because it provides direct evidence of the agreement that was made. And so courts don't have to look at all this confusing contextual evidence. And also in Massachusetts, certain contracts are required to be signed and in writing. So these include contracts for real estate, contracts that will be performed at a point longer than 1 year, and anything that is for the sale of goods over $500. And also, sometimes contracts need to be accepted in writing because the person who's making the offer specifies that this is the way it must be accepted. So for example, Doug says when he sends his counteroffer, please reply to this email with a signed contract by Tuesday at noon to accept my counteroffer. So you can always do this and make it very clear that this is the only one way to accept a contract. So the last section that I'll talk about for now is how do you modify a contract? So generally speaking, you need mutual written consent, signed and dated. And this is especially important because most written contracts have a clause that require any modifications to be in writing. And so what this can look like in practice, we'll turn back to Doug. And let's say that Doug's first location is doing so well in Dorchester that he decides to open a second location in Jamaica Plain, which means that he will now need linens to be washed for 2 locations instead of 1. So what Doug does is that he discusses this idea with Berkeley at an in-person meeting or a phone call, and then later emails Berkeley a written modification stating that he will now be paying $175 per week for linen washing services at his 2 locations. And both parties sign and date the modification. Now I'll turn it over to Sasha, who will lead us through common terms in a contract.
Great. Thank you so much, Dee, for that wonderful introduction into the world of how contracts are formed. And also thank you for introducing us to Doug, to whom we will return a number of times throughout the rest of the presentation. Now I want to go just one level deeper and talk a little bit about the common terms that appear in most contracts. So here is a agenda of what we're going to be looking at, from parties to representations and warranties to dispute resolution. We're going to cover all of it. So buckle in and let's get started without further ado. First being parties. So as you may know, one of the main functions of a contract is to allocate risk between each of the parties. But in order to do so, obviously, you need to know who the parties to the contract actually are. In other words, who is agreeing to do what. This, therefore, the essential first element of any contract is defining who the parties to the contract actually are. By parties, we mean who is entering into the contract and who is now bound by its terms. The party to a contract can be an individual, so in your personal capacity, like Doug, for example, or the party to a contract can be an entity. For example, this could be your business, an LLC or a corporation. Generally, at the beginning of any contract, the parties are defined, like you can see on the screen. So, for example, the beginning of the contract will often state X entity party, a Massachusetts corporation located at this address, or the party could be an individual at a certain address. But you may be asking yourself, why is knowing who the parties are really important? Well, not only is the party responsible for upholding their end of whatever bargain is set out in the contract, they're also entitled to whatever rights were agreed to in the contract. So, in certain situations, like if a party fails to uphold their end of the agreement, let's say, for example, they fail to deliver goods by a certain date, then they may be required to pay a certain amount as determined in the contract itself or by a judge in litigation. And here's a tip. So as a business owner, having a contract in an entity's name rather than your individual name may also shield you from incurring personal liability. So for example, if you have an entity like an LLC, you want to make sure that you're signing contracts in the LLC's legal name and not your personal name like Doug Smith. You want your LLC entity to be held responsible for the obligations set forth in the contract and not you personally. This avoids you getting sued in your personal capacity where your personal assets like your home or your car would be at risk, and rather than your company and its assets. That being said, an example where you may not avoid being able to be personally liable is if a lender insists on a personal guarantee. A personal guarantee is a provision that a lender puts either in a business loan agreement or it can come up in a commercial lease that requires owners to be personally responsible for their company's debt in case of default. Lenders often ask for personal guarantees because they have concern over the credit history or the age or the financial stability of your business. Each of these situations, understandably, presents a certain level of risk for the lender, and so a personal guarantee decreases that risk. So just remember, if you sign a personal guarantee, that might trump other protections that your business entity provides. Moving on to effective date. The effective date in a contract is especially important because it refers to the actual date that the terms of the contract become binding and when the obligations and rights of the parties kick in. The effective date is often pretty explicitly stated in the contract as the effective date, or maybe when this agreement goes into effect. In either case, the effective date represents an actual date at which parties become legally bound. Sometimes this date is the same date that both parties sign the contract, and so the obligations kick in immediately. Other times, the date is explicitly stated as a different date than signing. This date helps when enforcing your contract and also protects both parties in the event that the other party fails to perform their obligations. Okay, now let's talk about term. A term provision is a contractual provision that serves the simple but critical function of defining the period over which a contract has legal effect. In other words, it establishes when the contract begins and how long the contract will last. So, for example, a contract may only be in effect for 1 year, which would be its term. Note that some contract provisions may last indefinitely, or at least for a period of time after the contract ends. So it's always important to read the full contract carefully. Some term clauses will also allow you to renew the contract. When considering how long you want the contract to last, always be sure to note any language mentioning renewal in the term clause. And you can see on the screen, there's an example of some renewal language that says, the lessee shall have an exclusive option to renew this agreement by providing lessor with written notice of its intent to renew within 30 days of the expiration of the term. Now let's talk about termination. Note that the term of the agreement is a very different thing than the termination clause within the agreement. A termination provision allows parties to voluntarily terminate or end an agreement. It empowers one or the other party to decide if and when they want to end the contract or no longer perform their obligations. One example, as you can see on the screen, is the agreement shall terminate upon the default of either party. So here in this case, using this example, should either party fail to do something required of them in the contract, the agreement would automatically terminate. Now, note just for yourselves that this is called breach of contract, and we'll talk about that later on in the presentation. The right to terminate may also be given to a party in the event that the opposing party fails to fulfill their end of the contract or for no reason at all. The second option is called without cause. However, there always may be certain tasks you need to carry out in order for a termination to take effect. For example, you may have to provide written notice, which means giving the other party in a formal communication and oftentimes in a written letter X number of days notice that you're going to officially terminate the contract between you and your counterparty. To make this a little more concrete and to bring Doug back into the mix, imagine that Doug and Berkeley Linens agree to the following provision in their contract. Either party may terminate this contract by written notice to the other party at any time if the other party commits a breach of this contract. So, taking this provision, if Berkeley Linens fails to uphold its end of the bargain, Doug would have the option to send a formal written letter to Berkeley Linens informing them that he wishes to terminate the contract, and this would end the contract between them. Moving on to something a little different, let's talk now about representations and warranties. Representations and warranties, you may have heard of them, are present in most contracts, but they're particularly important in contracts related to some kind of sale. Legally, these are actually two completely distinct topics, but for practical purposes, representations and warranties tend to come together in a package, and the differences between them in practice are negligible. So we talk about them together because both are assurances that one party gives to the another party in the contract. Starting with representations, representations are statements of present or past fact within the contract. In a sales contract, one of the representations that you might have is that the seller really owns the property being sold and has the ability to sell it. Sellers commonly also represent there are no undisclosed problems with the thing being sold, or that financial disclosures made in connection with the sale are accurate. Buyers also might have to make representations as well, and usually these representations are about the buyer's authority to make the purchase. In terms of warranty, most people have seen a piece of paper labeled warranty, which guarantees a product is free from defects and promises a refund or a replacement for a stated period. Like a representation, a warranty usually includes a statement of fact, but it goes a step further by guaranteeing that the statement is true. Therefore, unlike representations, which are based upon past and present facts, a warranty may include a guarantee that the facts won't change. At their core, both representations and warranties are contractually binding statements of fact that give both parties assurance that the transaction is in fact what they believe it to be and gives them legal recourse if it isn't. Another common term in contracts is a confidentiality clause. A contract confidentiality clause prevents signing parties from divulging information the parties consider proprietary or confidential to the public, market competitors, or other third parties. These clauses can be unilateral, meaning only one party is required to keep information confidential, or they can be mutually binding. Depending on your company and industry, the confidential information could include things like you see on the screen, business information revealed during discussions, analyses, proposals, and negotiations, could be inventions, it could be personally identifiable information about your employees or your clients, or it could even be trade secrets. Ultimately, using a confidentiality clause in your contracts is one of the best ways to keep your confidential information away from the public or potential competitors. Okay, this is a big one. Another common provision in contracts is an indemnification or an indemnity provision, also sometimes known as hold harmless provisions. What these provisions do is that they shift risk or potential costs from one party to another. More specifically, in an indemnification provision, one party to the contract promises to defend in litigation and pay costs and expenses of the other party if specific circumstances arise, Often this will be a claim or a dispute with a third party. Indemnification clauses allow a contracting party, one, to customize the amount of risk it is willing to undertake in each transaction and with every counterparty, and two, protect itself from damages and lawsuits that are more efficiently borne by the counterparty. Indemnification, like some of the other contract clauses we've talked about, can be mutual, meaning that the seller indemnifies for some matters and the buyer indemnifies for some other things, but it depends on the bargaining power of each party. Indemnification provisions typically create more risk exposure for and are therefore more pertinent to sellers than buyers. So in case this is still a little shaky, let's explore indemnification further through another case study. So consider the following scenario. Imagine that Doug buys a coffee machine from a company called Coffee Suppliers under a sales contract that has an indemnification provision requiring coffee suppliers to indemnify Doug for any third-party claims related to the topic of the contract, which is the sale of the coffee machine. But imagine that Doug doesn't like the machine, and so he resells it to Susie. But unfortunately, the machine malfunctions and it blows up in Susie's face, injuring her. Susie, understandably, sues Doug because he's the one who sold it to her, and he's forced to pay Susie $1 million. We come back to the indemnity clause in Doug's contract. The indemnity clause in his contract with Coffee Suppliers makes Doug whole by allowing him to collect $1 million from Coffee Suppliers as the manufacturer of the machine. Coffee Suppliers has to reimburse or indemnify Doug for the cost he had to pay to a third party, Susie. Coffee Suppliers may also have to pay Doug's court costs and legal fees along the way while he is battling in court with Susie. That's indemnification at work. Moving on, limitations on liability. Limit of liability, also known as limitation of liability, is a clause in a contract that limits the amount a party has to pay to the other party if the latter suffers losses due to the contract. It also caps the types of compensation one party can recover from the other. This clause typically covers losses caused by the following: negligence, that is, if one of the parties fails to meet a reasonable duty of care and causes harm to someone; breach of contract, where a party fails to fulfill its contractual obligation; infringement of intellectual property rights. This is where if one of the parties infringes on the other's intellectual property rights, such as a patent or a copyright or a design right or even a trademark. And finally, misrepresentation, where a party makes a false statement that misrepresents an aspect of the contract, such as the quality of the products that they're selling. Another common clause is a dispute resolution clause. This clause will outline how parties should respond in a dispute and the preferred dispute resolution processes, and will avoid premature and unnecessary court proceedings. These clauses are reflective of the understanding between you and the other party of what should happen in the case of a disagreement. The key elements of a dispute resolution clause are: 1, notice periods and timelines for addressing the issue; 2, a request to negotiate first. For example, a dispute resolution clause may require you or the other party to organize a meeting where you can both openly raise any concerns and negotiate a solution to the problem. This approach can promote collaborative problem solving because you can usually make offers or statements with no risk of them being used against you in court. 3, an alternative dispute resolution mechanism. There are many different types of alternative dispute resolution mechanisms, some being conciliation, mediation, and arbitration. But here's a tip on that. Be aware of the danger that can be posed by mandatory arbitration agreements. Oftentimes, by agreeing to arbitration, you're giving up your right to sue later. And this can be a serious problem, especially if you're entering into a contract with a much larger company. While they differ in important ways, these types of alternative dispute resolutions all typically require an independent third party to facilitate a discussion between you and the other party. Also note that arbitration and litigation can be very expensive, and so negotiating dispute resolution clauses can be difficult. Nevertheless, trying to negotiate for less expensive alternative dispute resolution processes like mediation can be really helpful. And finally, number 4, timing and location for legal proceedings. A good dispute resolution clause should require parties to attempt to solve the dispute first using any of the above methods before resorting to litigation. But in some cases, as life is, litigation will be unavoidable. Dispute resolution clauses should reflect this and set out where parties can engage in legal proceedings. These clauses will do so by stating that the laws of one state or country apply to the contract. Especially if your business operates in a different location to your contract's counterparty, you should make sure that it's clear where legal proceedings will take place if a dispute arises. In sum, without a dispute resolution clause, you may need to jump directly to legal proceedings to resolve the issue. Unfortunately, going to court is expensive, uncertain, and time-consuming. And so, to reduce your risk of this outcome, a dispute resolution clause is often effective in preventing you and your business partners from resorting to suing each other. Okay, now we're going to turn to something a little bit different, and we're going to focus and drill down into breach of contract. So, you may be asking, what is a breach? A breach of contract is a violation of any of the agreed upon terms and conditions of a binding contract. The breach could be anything from a late payment to something more serious, like the failure to deliver a promised asset. Some common ways parties can be in breach are non-payment for goods or services rendered, defective work performed by an obligated party or defective goods sold, failure to provide goods or services in a timely manner, breaches of express or implied warranties, or finally, the breaching party performed an act it was expressly forbidden to perform under the terms of the contract. This would be something like a non-compete or in the context of an employee conduct contract. So just using our case study and going back to Doug, imagine that he fails to fulfill his promise to pay the $175 to Berkeley Linens. If he did that, he would be in breach of contract. But note that there are multiple types of breach of contract. There's material breach and minor breach. Material breach happens when one party ends up with something significantly different from what was specified in the contract. So imagine that Doug, for example, agrees to sell coffee beans to a client, but instead, for some reason, he delivers them tea leaves. This is something totally different than what was contracted for, and so this would be a material breach. In most cases, a material breach means the non-breaching party is no longer required to perform his or her end of the deal and has a right to remedies or money damages. Now, on the other hand, minor or partial breach occurs when one party fails to perform some really small part of the contract, even though the specified item or the service was ultimately delivered. So you can imagine that Doug agrees to sell coffee beans of a specific type to a certain client. And in the end, he does sell them coffee beans, but he sells them coffee beans of a different type. This would be a minor breach because aside from the departure from the one specific instruction about the type of coffee beans, all other parts of the contract have nonetheless been completed and delivered. When there's a minor breach, depending on the terms of your contract, a party can sue for damage, but cannot break the agreement, which means that they must still uphold their end of the bargain. So that client has to still buy the coffee beans from Doug, even though they're of a different type than they originally contracted for. Now, you may be asking yourself, what do you do if the other party breaches? Breaches, as you probably know, can be fairly common in the business world, but what may initially look like a breach could just be a misunderstanding. So the first step here is to determine whether or not a breach actually occurred, which will require you to reference your contract. If you're unable to speak with and get it resolved with the other side, and you do have to go to court, in most breach of contract cases, there's 4 things that you have to verify. First, the contract actually existed. 2, the contract was actually broken. This requires you to review your contract to make sure you know exactly what it says about how it can and cannot be broken. 3, you lost money. And 4, the defendant, meaning the person or the business that you're challenging, was actually responsible for the breach. You may be thinking to yourself, what do you do if I want or need to breach my contract? There are 3 initial questions that we like to consider as important. Number 1, how will this affect your business reputation and your business relationships? 2, what will be the impact on your time and your money if you're sued? And 3, what will happen if you lose a lawsuit for breach of contract? In either case, whether it's the other party or yourself that wants to breach a contract or needs to breach a contract, you want to minimize the damages that could result from the breach. Moving on to remedies for breach, what do you get from a breach of contract if you go to court? Generally speaking, the goal of contract law is to ensure that anyone who is wronged is left in basically the same economic position that they would have been had no breach occurred. So as a result, the default remedy available for a breach of contract is monetary damages. So let's just say you completed a job for which a contract stated you would get paid $50,000, but you only got paid $20,000. Under breach of contract, you could be awarded damages of up to $30,000 to make up that difference. However, as we discussed above, there are all types of terms that can be written into a contract that change this. For example, a limitation of liability clause could affect how much money you could be awarded in damages or would have to pay if you were the one being sued for breach. Another remedy for breach of contract is specific performance. This is forcing the breaching party to hold up their end of the bargain. And it's much, much less commonly employed than money damages. Generally, specific performance is only ordered if the subject of the contract is unique or where there's no amount of money that will make the non-breaching party whole. So, going back to our case study, imagine that Doug enters into a contract for the sale of a specific building from which the owner pulls out. That breach might result in a specific performance order requiring the seller to complete the sale to put Doug in the position he would have enjoyed if the contract had been honored in the first place. This is because buying a specific property is unique and being compensated monetarily doesn't make you whole. If you do end up in court and have to deal with a breach of contract case, what can you expect from the judge who's going to be reviewing your contract? So, in other words, how are contracts interpreted or enforced by the courts? The first key principle is that words will be given their natural and their ordinary meaning. The starting point of a contract interpretation case will always be a straightforward, objective reading of the actual words on the page. What does it actually say based on the ordinary meaning of the words that have been used? Second, prior negotiations are typically unlikely to be given as much weight. This includes drafts of the contract or any related communications like emails, calls, meetings. An important point, therefore, is to understand that to make sure that you read and understand your contracts and that what is on the page actually reflects the terms you and your counterparty discussed. A court will not set aside a contract that you signed just because you say you didn't understand what you were agreeing to. And 3, finally, external factors can help define ambiguous terms but are secondary to the plain text. This is things like purpose of the contract, industry jargon relevant to the sale or service or topic of the contract, common commercial sense, and facts and circumstances around the parties at the time of contract formation. These things can all come into play and modulate the way that a court will look at ambiguous terms, but the plain text will always come first. And to wrap up breach of contract, we wanted to talk about what some of the common defenses to breach of contract claims are. You can see them on the screen, but if you do find yourself in the unlucky position of being a defendant in a breach of contract case, there are certain common defenses that could apply to your situation. These include but aren't limited to, for example, waiver. This is when a party can argue that its counterparty conducted itself in a manner that actually acquiesced or accepted the breach, thereby waiving any argument against it. However, many contracts will have a clause that limits this defense. Another is statute of limitations. Every state has statute of limitations, and if the person who wants to sue misses the legal deadline for bringing a lawsuit, they're barred from doing so. Another defense is impossibility. The contract has become impossible to perform because a fundamental assumption to the contract no longer exists and neither party caused the problem. This is a very difficult standard to meet, so it's somewhat of a misnomer to call it a common defense. Similarly, impracticability. Performing the contract would lead to a severe and unforeseeable hardship that is beyond the terms of the agreement. This is, again, a really difficult standard to meet. Legal incapacity is another one. So that's if a party doesn't have the capacity to enter into contract either because they're a minor or they're mentally incompetent, then that contract cannot be enforced against that person. And lastly, Dee mentioned this, statute of frauds. Certain contracts by law must be in writing and signed by the party against whom enforcement is sought. So if you've breached an oral contract that should have been in writing, you can argue that the contract was invalid in the first place because it violated the statute of frauds. And with that, I end my section, and we'll start with some practical tips, which I will turn over to Dee to cover.
Great. Thank you so much, Sasha. I know that we've thrown a lot of information at you during this presentation, so hoping to wrap this up with quick 5 takeaways for you all. So tip number 1 is to be careful when using form contracts. So form contracts are template contracts that have standardized legal terms. They can be very convenient because they allow for consistency amongst contracts with different parties and also allow you to make contracts without needing to consult a lawyer every time. Next slide. Oh, yes, thank you. But problems can arise when form contracts aren't customized and not tailored to the party's specific situation and can lead to issues with contract enforcement and clarity. And so whenever you're using a form contract, just be very meticulous about reading through and making sure that everything is relevant to your business. Number 2 is make sure that you understand the legalese. And what we mean by this is contract language that is obviously different from what we use in everyday life. If in some case you don't understand exactly what you're signing, this can prevent you from being aware of the rights you have under the contract as well as the obligations you have to the other party. Number 3 is we've said this before in the presentation, but written contracts are the safest. And so we recommend that you sign and date every contract that you come across and require other parties to do the same, and that you also keep an accessible copy of the fully signed contract on hand. Number 4 is to be specific in your contract terms. So by this, we mean be very specific about the meaning of a term. And this is just looking ahead. If in some case a court were to interpret a contract, their main priority is figuring out the parties' intentions at the time that they sign the contract. And the easiest way to do this is to look at the actual language itself. So anything vague can be very difficult for a court to interpret. And then last tip number 5 is to avoid accidental contracting. So make sure that everything that's leading up to contracting, all the negotiations and back and forth, that you have something in your communications that indicates that this is not the final contract. So some ways you can do this include when you're writing an email, having something in there that says this email does not constitute an agreement, or even in making working drafts to have in the heading something that says draft or for discussion purposes only up until you have something final. And then lastly, like I talked about in the beginning of this presentation, include something in the final agreement that says that modifications need to be in writing for clarity. So those are our tips, and briefly touching on when you should hire a lawyer. The most ideal situation is that you speak to a lawyer before you sign a contract, just so that you understand all of your obligations and rights and are balancing risk well going into the agreement. That being said, obviously, legal services can be very expensive and cost prohibitive. And so we encourage you to look into organizations that provide services at a lower cost or pro bono. Of course, this is what we do at the Transactional Law Clinics, where there's law students and supervisors who work on different cases through the semester. And so if at any point you have some sort of business need with contracts or anything else, feel free to give us a call at our intake line or visit our website. And that way we can get the process started of evaluating whether you're eligible for our services.